minutes. Now, this current session is about Section 8 and other forms of denials, including voluminous information layer. Let me say that I am just about 2.5 months old as the CIC, and therefore I cannot claim to know quite a lot, but still I can talk certain things about it. Now, by way of introductory remark, I am making one observation. Many of you may like it, may not like it, but still it does not matter. Like the right to information is something like a line to be drawn between, let us say, the Harry Potter's invisibility cloak, where nothing is seen, everything is opaque. Or we have the modern days total body scanners in many of the airports, where everything is seen. While nothing is seen, the second it is obscene. So we have to draw a line between this and that, wherever, and that is what this section provides, different layers by which we can stretch up to. And this is only an introductory remark. I would like to listen to you. Many of you are much more experienced than myself. But there are certain safeguards which you will have to take, especially if it involves certain economic activities. I did come across two cases where, without naming the case, let me say that a particular gentleman, an officer from the government, he was involved in a particular activity. So he was placed under suspension, and then subsequently a vigilance case was instituted against him on various grounds. Now, he wanted that very detail which is required to be furnished before the High Court, so that he can say that he is being harassed by the government for etc., etc., etc. Now, the records were summoned and found that this individual himself was involved in certain transactions which would have a larger impact on the economics of the state. Do we give or not give? This is a real dilemma. The High Court on the one hand wanted those information, whereas the furnishing of such information would really be detrimental to the economic interests of the state. I said, no, we will not give. I went through the entire documents and said, we will not give, despite the High Court being involved in the case being pending. I just stop here. Let me listen to you, and then we will discuss further. Thank you.
We had promised, Mr. Chairman, with your permission, that we would take on board, and Colin, I think you're still on track with that, any inputs that they might have about their expectations, which we started. Right. I want to spend 5 or 7 minutes on that, and then is that all right with you? So we had put across what our expectations were. If anybody has any further expectations from this group which are reasonable, I would say, what is the phrase, speak up now or forever hold your silence. So in the next 5 minutes, if anybody has any further agenda points to suggest, let's get them on board, and then let's get on with the agenda. Okay, I was hoping nobody did, but yeah. Sorry.
Motivated now to plug up this expectation. Maybe in the evening, this evening, or at some point of time beyond this session, if we can have a small open session to discuss the nuances of the CPC and also the other laws which have Evidence Act, etc., etc. It will be very, very beneficial to me actually. I can guarantee that. And if there are others, then we can join and we can have a small gathering to discuss that.
Yeah, that could be a dinner subgroup, Colin.
Yes.
You leading the discussion.
Yes. Yes. In fact, after this, those who are interested, we're having dinner at the Human Rights Law Network office close by. So we'll have an early dinner and discussion first and dinner.
CPC and evidence, nuances.
Sure. I think one thing that's been left out, which when we talk to commissioners, and I talk to commissioners, I do feel that commissioners have expectations from civil society, or they feel there are genuine problems in the way civil society or activists approach RTI. Whereas it is fine, yes, the commissioners must respond to what civil society wants. If we want a better dialogue, it may not be a bad idea For the commissioners to say the problem they see with civil society, I mean, like he did mention one, but there are other problems that commissioners do voice. Typically, it's done in a closed room, only between commissioners. I think it may not be a bad idea for us to discuss these also.
Can there we talk?
One moment.
Sir, I am Vikram Singh from Karnataka. Sir, you elaborated the various deficiencies in the interpretations of the orders. My one good suggestion, which I feel, is that can we have a peer review with all the information commissioners?
Peer review.
Peer review.
You mean in this workshop?
Not in this workshop, a regular feature.
Can we discuss about some orders which some of information commissioners gives? They discuss everything except RTI. I have got a very peculiar, funny order from CIC. If I am allowed, I can.
Not right now. You know, there is a sensitivity in discussing specific orders because these are judicial bodies which would not like to discuss specific. See, if it's their order, they can't discuss. If it is somebody else's order, then also they can't discuss. So it's not going to be a very good thing in this forum.
I don't want to discuss about the orders. Whether the orders under RTI, whether these orders are at all wanted or not.
Okay,
Can information commissioner gives that you give us this refund, you apply for this, you apply for that, without giving that the information which has been sought must be given.
Yeah. Well, let's keep this as a general principle and see if it fits into the thing. I'll try and make sure it does.
Excuse me. Yeah. I'm Gunavardhan from Kerala. See, my expectation mainly is since this is a judicial colloquium, and there are so many eminent lawyers and similar knowledgeable persons around, some clarifications which the commissioners can also make use of. Can I cite an example? It is regarding Section 8 itself. See, in Section 2E, the word competent authority is defined. Section 2E. In Section 8D and Section 8E, again, the word competent authority comes there, where the definition given in Section 2E may not be most appropriate to apply. So I would like the forum to discuss if it is found possible.
There is withdrawal of applications during hearing by the applicants, whether under coercion or in agreement with the concerned department before the commission. So that is, creating a problem as it is nearing to penalty. Applicants are withdrawing, and in that case, what is the legal position? Second, very often the commissions are giving a judgment on the basis that there is no mala-fide intention, so there won't be any penalty. But this mala-fide intention, whether there should be any substantive cause to it, on that also there is a very grey area, because very often they find that we consider it is that there is no mala-fide, so there won't be any penalty. So what can be the guidelines on that basis? And the third aspect is, very often the applicants, while seeking information, are facing threats or abuses, or there is attack also on applicants. So in that matter, does the commission has a role to play, and what power or legal position the commission has in case of that? The fourth one is regarding definition of information. Sometimes the commission gives the opinion that this is not information.
That we are taking up. Let's already do some of these other things also, but we've already fixed up one dinner discussion and we'll try and see what else can. Now I'll quickly go through what is the menu for these two sessions which we have running in. Based on the data that I had already mentioned have been collected from across the country, it was felt that there were 3 or 4 sections of the law that needed to be discussed in much greater detail. One was 8.1e, which is the fiduciary relationship section, which has been used variably all across the country. Fortunately, very recently, and we have an information commissioner from Kerala, so he'll be aware, there was a very extensive order from the Kerala High Court. Irish, this lady's, the order about her appeal, she was a post-human who applied for her exam results, which gives a very detailed discussion on what is possible and not possible under the fiduciary clause. Vijay, you have that as a part of this document, isn't it?
Yeah.
Is it flagged or is there a page number?
Nothing is there.
Can you tell us which page number it is? Then he'll tell you, because we need to alert them on whatever we are going to be doing for you. So that's the first one, 8.1e. I'm just putting across what we have identified, and let's then discuss those and then we'll move on to other things. The second is 8.1h. In fact, our statistics also show 8.1h is about matters which are currently under investigation or where the prosecution, etc. Information, I'll read it out so those of you who might not be totally familiar with it. It is information which would impede the process of investigation or apprehension or prosecution of offenders. Now, this is something which has been extensively used. It's also perhaps one of the most commonly used clauses, because our research showed that a large proportion of the RTA applications go to police at the center and states, and the police uses it all the time to deny information. Not only that, under this lots of other things get pulled in. For example, there is a very common for information commissions and for PIOs to say that it's sub judice. So under this we cannot release it, though there is no clause which says that just because a matter is sub judice, you cannot access it under the RTI Act, but this is used. So this is the second clause that we would like to discuss. The third one which we would like to discuss is 8.1j, which is personal information or privacy. And this is again something which is extensively being quoted, being misused, etc. And this links up incidentally to section 11, which is the third party one, where very often information is denied because it is third party. But the law doesn't allow that. What the law says is if it's third party, you have to, under a certain procedure, give notice, etc. The law also doesn't say that if the third party objects, then you can't give the information. It only says you have to take on board the views of the third party and then see if that person has made an argument which is acceptable to determine that it's excluded under any of the existing clauses. But this is very often used in different stages, either that it's personal, so what does the personal, or because it's third party, it is rejected, etc. Then the next one is section 2F, and this is where the gentleman you had raised this.